Good day, Crime Talk aficionados. I am back, and we have a great show for you today. First, let's talk about the blood evidence of the two unidentified people in the Bryan Kohberger matter. Does it exonerate Bryan Kohberger? The father of the Georgia school shooter gets a bond. Will he make it? The lead investigator in the Karen Reed case, you know, the one on leave, unpaid leave for inappropriate conduct. Apparently, there's some more inappropriate text messages. A former pastor pleads guilty. Get your minds out of the gutter. It's not for that. He tried killing his family. A 72-year-old has still got it. Hookers and blow. This day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications so that you get notified of when we go live or put up new content. Now, I apologize. I missed a show yesterday. Had to go to the other side of the state, was in court, and, well, you know, things don't always turn out the way that we hope they will. Anyway, we are back, and we have a great show. Before we get to the show, though, going to remind you to go to crimetalksearch.com. That's where you can sign up for that background subscription service today. And when you do, you'll be able to do a background search on as many people as you desire. So whether you want to do one search or 1,000 searches, it's all the same price. And remember, you can cancel at any time. And you can do that background search on anybody that is coming into your life. Maybe somebody that makes those spidey senses tingle, that you think something's just not right. Maybe it's that new boyfriend or girlfriend of the kids. Check them out. Check out the family. Go to crimetalksearch.com and you'll get that background search literally emailed to you while you wait. And it's going to have everything you want to know about that person. So whether it comes up full of all kinds of information or there's nothing there, at least you know you have the peace of mind you checked them out. Remember, it could save your life or someone around you. Go to crimetalksearch.com. You're going to be happy that you did. All right, let's go ahead and open the record for February 13th. And first on the docket, the Bryan Kohberger case. All right, been a lot of talk all of a sudden about some statements that were made in the motions hearing as it relates to Bryan Kohberger last week. There's a couple of pending motions that are causing a big brouhaha. We've talked about the motions. Most of the pending motions that have not been resolved relate to the affidavit that the police submitted to basically arrest Bryan Kohberger, as well as that information that led to all types of other evidence that led to Bryan Kohberger. Needless to say, we've talked about this, and you're getting this from somebody who's practiced criminal defense for 3 decades now, is that you want those things to go away. That's the crux of the case. So let's kind of lay the groundwork here. We'll find out, we'll frame the issues, what the issues are, and we'll see if Bryan Kohberger is going to be exonerated or if this unidentified blood DNA of 2 other individuals exonerates Bryan Kohberger, or does it just simply say he had co-conspirators? Let's talk about it. So, detectives who investigated the Moscow College student homicide found blood at the crime scene from still 2 unidentified males. Now, attorneys for Bryan Kohberger revealed at a recent hearing, hinting to a possible legal defense strategy at trial. Now, an unknown individual's blood DNA was discovered on a handrail in the off-campus home where the 4 University of Idaho students were fatally stabbed. Another unknown blood sample was found on a glove that police located just outside of the home. Now, like I said, this was in the hearing that we brought to you. We can put a link to that, so if you want to watch it for yourself, all right? Now, in the bed of one of the stabbing victims, police say they also found what many regard as the case's key piece of evidence, which I believe is the key piece of evidence. It is a leather knife sheath from a K-bar, right? And during the processing, DNA was discovered on the sheath and later matched directly to Bryan Kohberger. That's right, here on this little button right here. Okay, this is my own personal K-bar. Had it since 1988 when I went to boot camp. What other show has their own K-bar? Not a single one. Anyway, that DNA matched directly to Kohberger, and police and prosecutors, that's what they're alleging in their filings. Now, in the legal filings from the June 2023, defense attorneys said the state's claim is not from blood, but rather from touch DNA on the sheath located at the scene. Now, in those same filings, the defense said DNA from 2 additional males was found inside the home, and the male DNA was found on the glove outside. Now, the prosecutors have stated to the court at that hearing in August of 2023 that those DNA samples were not uploaded to try to identify them through the FBI's National DNA Database, known as CODIS, because they apparently were not eligible based upon the criteria. Normally what that means is they were maybe not able to get enough of the unidentified male DNA, enough loci for the samples to be sufficient enough to go into CODIS. I see that quite often where they'll have unidentified, say they only get 3 loci of maybe the 17 that they tested, and therefore it's not sufficient to be uploaded into that database. And once again, even if there was blood there, it could have been from nights before. Who knows how somebody could have been there, had a party, cut their finger, opening a beer top. Who knows? But it's there. The defense is going to try to make some hay out of it. Now, it was not publicly known until last month's court hearing that at least 2 of the unknown male DNA samples came from blood. Now, the type of the 3rd male DNA sample remains unclear, as is whether its source has been identified. But police did not disclose this unidentified DNA sample to the magistrate judge back in December of 2022 when they sought a warrant for Bryan Kohberger's arrest. Now, the defense attorneys alleged at the motions hearing that the prosecutors did not dispute that it didn't go into the affidavit, and the decision amounted to detectives intentionally omitting the information to the judge for her determination of probable cause, and then should disqualify some of that evidence, is what she's trying to say. She's saying, you didn't tell them everything, therefore it's not a valid search, and we want some remedy for that. We'll discuss that more when we get to the Franks issue. All right. Now, in the bed of one of the stabbing victims, police said that they also found what many regard as the case's key piece of evidence, the leather knife sheath, right? Or obviously the blade that was not found and never been found. Now, during the processing, DNA was discovered on the sheath and later matched directly to Bryan Kohberger. So the defense is arguing that the decision to intentionally leave out the source of these 2 other unidentified blood DNA samples was intentional, and they intentionally omitted that information to the judge for her determination to probable cause, and therefore they want to disqualify some of that evidence, according to the defense argument. Now, the unknown male blood DNA samples police found inside and just outside the King Road home raise important questions about the investigation, the defense is arguing. And Ms. Taylor, Bryan Kohberger's attorneys, said that the evidence, which she argues is material and exculpatory, meaning it supports Bryan Kohberger's claim of innocence, and that was directly kept from the judge ahead of their client's arrest. Now, the information is not necessarily exculpatory for Mr. Kohberger, the judge noted to her. Rather, it could suggest the possibility that other suspects were involved. If you assume that the blood was related to the victims and not some earlier event in the house, the judge noted, regardless of if the defense prevails in convincing the judge to grant a Franks hearing or to suppress other states' evidence, it's likely that Kohberger's attorneys will use the unidentified blood DNA from the crime scene to try to, create reasonable doubt at trial. The primary challenge for the defense in Kohberger's capital murder case here will be explaining to the jurors why the knife sheath just happened to have his DNA on it and just happened to be at the scene underneath one of the victims that the defense notes that they had no relationship to the victims in any way. Some people say it could have got there by anybody. It could have been planted, but how would they have known to plant it for Bryan Kohberger's DNA if they didn't even know who he was at the time? And why would they plant it? And obviously that's the thing that squarely puts Bryan Kohberger at the scene. The magnitude of that evidence to the state's case is obviously critical. And, well, we can't understate it at all. That is their case, ladies and gentlemen. If that goes away, there is no case against Bryan Kohberger. Now, Kohberger's defense team has said on several occasions that he is innocent of the crimes for which he is accused. And Ms. Taylor, his lead attorney, reiterated that at last month's hearing, that no connection exists between her client and the victims. In spite of these allegations, Bryan Kohberger has never been to the King Road home, she said. And police executed a search warrant at Kohberger's apartment and sought a variety of evidence. That included all DNA evidence, which entailed any items with blood, bloody fluids, human tissue, skin, and cells. Initial analysis from the presumptive chemical tests on the stained mattress cover and pillow taken from Bryan Kohberger's apartment came back positive for blood, according to police records. We're assuming it's his blood because we have no reason to believe it's anybody else's blood at this point. Next, the King Road residence contained a significant amount of blood from the victims, including splatter and cast-off bloodstain patterns and from blood drops released from an object due to its motion, which is based on the officer's training writing the warrant. That's why he put this particular language in the warrant, which makes it likely that this blood evidence was transferred to Bryan Kohberger's person, clothing, or shoes. The Moscow Police Department wrote in their affidavit for the search warrants. But none of what was seized related to the 4 victims, according to his attorneys. During the search of their client's apartment, in addition to 3 searches of the white Hyundai Elantra, police found absolutely no connection between him and anybody from the 1122 King Street address. There's no blood in his car, his attorneys noted. He wasn't connected to the house, to the people in the house, and during the court-approved search, his attorneys note, police pulled the apartment apart. They took apart components, including the brake, the gear shift, and key fob remote of Kohberger's car. Nothing tying Kohberger to the victims was found in the steering wheel either. One of the victims in the stabbing, Kaylee Gonzalez, owned a dog with her ex-boyfriend, and the police found it in her 3rd floor bedroom when they arrived at the crime scene. Now, according to the probable cause affidavit. Now, the door to her bedroom was opened and was Mogan's 3rd floor bedroom where Gonzalez and Mogan were found deceased. Now, Taylor told the court at the hearing this dog had not tracked any blood around, she said. The dog had no blood on it whatsoever, but it was just sitting in an open room a day later. Now, police suspected Kohberger returned to his apartment after this violent knife attack, hoping that they would find something. But as we know, as of right now, there is nothing. So at that time, it is likely that he still had blood or other trace evidence on his person, clothes, shoes, including skin cells or hair from the victim's dog, the officers wrote in their affidavit. And it is likely that some trace evidence was transferred to areas in the apartment through contact with the items worn during the attack. Once again, per the search warrant. Now, a search warrant return showed that 24 items, including at least 10 possible hair strands, one that was possibly from an animal, and 3 more possible hairs among all that police seized from Bryan Kohberger's apartment. Now, on a list of more than 50 exhibits the defense team submitted to the court in support of its Franks hearing, they included 2 FBI lab reports for hair fibers, each noting no connection. It is unclear if the 2 FBI reports the defense submitted relate to the possible hairs police located during the search of Kohberger's apartment. Anyway, the judge told the defense for Bryan Kohberger last month that a direct DNA comparison between the defendant and the knife sheath at the location of the quadruple homicide would seem to close the book on the matter of probable cause. The question jurors will have to weigh for a possible conviction is the proof beyond a reasonable doubt standard, the judge noted. There may be, as you say, other people that created concern or issues that need to be investigated, the judge noted, but I'm not sure that that diminishes the probable cause of Mr. Kohberger if his DNA is found on that knife sheath found on or near the victim, who was stabbed with said alleged knife, would have been in the alleged sheath, the judge also noted. And let's not forget, how did a sheath for a fixed blade knife get there? And how did Bryan Kohberger's skin cell allegedly wind up on it if he was not involved? Well, the defense team acknowledged that this is the most significant issue ahead of the trial. I mean, that's the ultimate question that will be before the jury, Bryan Kohberger's attorneys argued. What does a knife sheath at the scene mean? Hippler shot back, if you're killed with a knife, that probably means a lot. Miss Taylor responded, it might. So here's the issues, ladies and gentlemen. First, should the judge grant a Franks hearing? I don't think that he will. Now remember, a Franks hearing is based upon a federal case, Delaware v. Franks, where it states that police have to put in, obviously, the relevant facts to get a search warrant or an arrest warrant, but they also have to include exculpatory evidence. But they don't have to list every single piece of evidence that they find. Now, obviously, if there's some exculpatory evidence, then that would be something, if it was potentially excluded, that the judge would have to consider. However, when you're getting an affidavit for one particular person, the police may be thinking there are other suspects here. We have this unidentified blood. There isn't a sufficient sample, but that doesn't mean that you can't find probable cause for Bryan Kohberger. Now, does it mean just because they found probable cause that he'll be convicted? No. The government has a heavy burden to prove at trial, proof beyond a reasonable doubt, which is the highest form of proof known in the law, not just here in the United States, but anywhere else in the world. It is not a vague, imaginary, or a speculative doubt, but a doubt that would cause peoples to pause in matters of great importance to themselves. All right? So, do I think the judge is going to grant that Franks hearing to say that the detectives left something out? No. Even if the judge were to say they should have probably included it, but it doesn't mean that the magistrate judge would not have found probable cause to go and arrest Bryan Kohberger. It doesn't mean that all of the other warrants that they sought from Google and Amazon and his phone records, that somehow nullifies all of that. I don't see Judge Hippler making that leap. He is correct. Just because there's other blood DNA, they don't know who it is, they can't make out a sufficient sample, doesn't mean Bryan Kohberger wasn't there. All that means is there may have been other people involved, assuming you could say that that blood was there at the time of the murders. And if you can't say that, then it's just speculation. All right? So, is it going to get thrown out on a Franks issue? No, I don't believe it will. The issue here is the court finds probable cause, and the issue is framed exactly as the court noted. Will the prosecution be able to prove their case beyond a reasonable doubt that Bryan Kohberger caused the death of these 4 young college students on the date and place charged? And that's it. And this is where people get hung up. They always think that there's going to be some silver bullet that's going to make the case go away. And it's not. Everything for warrants is a probable cause standard. Would a reasonable person believe that a crime was committed? Well, obviously there was a crime committed. There were 4 dead people there, right? Would a reasonable person believe that Bryan Kohberger may have had something to do with it? May have had something to do with it, ladies and gentlemen. When your touch DNA, right? Your touch DNA just happens to be on the knife sheath underneath a victim at a crime scene, and you could say they were stabbed, I think that is probable cause. So this case is not going to get dismissed by the judge. My mouth would drop to the floor if that happened. I don't see it happening. This is a question of fact for the jury to decide. And like I said, a lot of people think, oh, there's going to be some great motion, it's going to be dismissed. Bryan Kohberger's innocent. There's not. Probable cause is such a low standard. He could have had his, preliminary hearing. He continued it. He got indicted. They've already established probable cause. That's it. Okay. The genetic genealogy stuff, the court is going to rule against the defense in that as well. Yes, it sounds like the FBI violated their own protocol to go to these DNA websites in search of this DNA profile that ultimately connected Bryan Kohberger's father to get it to go back to Bryan Kohberger. They violated their policies. Okay, that's certainly ripe for cross-examination. And I'm sure the agents will say, yes, we have policies, but sometimes, like all good rules, are meant to be broken because we were trying to solve the homicide of 4 young people, and we want to bring justice to them. So yes, we made the call to go against that. It's a policy. It's a guideline. It's not written in stone. We didn't violate any law. So genetic genealogy staying in, and I don't think we're going to get a Franks hearing. Now, like I said, I'm a criminal defense attorney. I'm always rooting for the defense, but sometimes you can't avoid reality. And if you go back and you look at all of my shows, I've said the biggest issue, and the judge knows it, the prosecution knows it, and the defense attorneys know it. It all comes down to this little knife sheath. If there's like an Amazon delivery for a United States Marine Corps K-bar, that's a problem for Bryan Kohberger. My guess is that's why they're trying to suppress those Amazon records. But hey, we haven't seen that, but I'm just taking a wild guess. Because remember, ladies and gentlemen, they suppress the evidence that the defense deems bad for them. And that's why they want it to all go away. Ultimately, it's going to come down to a question of fact for the jury to decide. Next on the docket, the Georgia school shooting suspect's father has got a bond. So on Tuesday, a Georgia judge granted the father of the Appalachia high school shooting suspect a $500,000 bond. Most people can't make a $500,000 bond, particularly when you've been in custody since September of 2024, because that's what went down on September 4th of 2024. Colt Gray, 14 at the time, allegedly killed 2 teachers and 2 other 14-year-old students when he opened fire inside the high school. Now, Colt pled not guilty to 55 criminal counts, including 25 counts of aggravated assault, and his 54-year-old father, Colin Gray, pled not guilty to 29 criminal counts, including 2 counts of second-degree murder and 2 counts of involuntary manslaughter. Now, the father is accused of buying an AR-15 style firearm for his son, allegedly used in the shooting. Now, on the bond, he actually got up and testified, which was very unusual, but it worked, I guess, to the extent that he got a bond. Can he actually make it, though? Anyway, so he got up and he testified, and the attorney asked him all these questions. Are you a flight risk? Will you comply with all the pretrial orders that the court were to impose? Do you have any criminal history? Do you have a residence where you can stay? All those types of questions were asked of him under oath. Like I said, the judge said, fine, I'll give you a $500,000 bond, and 10% of that is you have to post $50,000, through a bonds person, and normally $500,000 in cash, which if this guy had it, he would have been out already. Anyway, now prosecutors had asked the judge to set Colin Gray's bond at $1 million, noting that he lived in several different residences over a 5-year period with Colt. And if he returned, he would pose a significant threat to his wife and his other children, who the state intends to call as witnesses at trial. Now, Colin Gray's attorney, Brian Hobbs, argued that his client was not a threat to the community. And during the hearing, the court heard several victim impact statements from the victims of the shooting. And of course, they all said that they believe that he's a danger, that this never would have happened had he been a better father and supervising his son. As I said, the judge ultimately set a bond. We'll see if he actually makes it. Now, this is the second case following the case of the James and Jennifer Crumley in Michigan last year, where they were charged and convicted and ultimately sentenced to 10 to 15 years in prison for their roles in their son's decision to open fire inside his school, killing 4 students and injuring others. Now, the Crumley's parents' trials has been described as historic, as they were the first parents of a school shooter in U.S. history to be tried, setting a new precedent for parents of children accused of committing mass shootings. I didn't like the Crumley decision, unique, novel areas of law. Hey, I think at this point, all my kids are grown. They're over 18. I'm off the hook. But for the rest of you that got young kids, I think your kids screw up in any way, charge the parents. Don't worry. They're not just kids. You should have been a better parent. And I think the other thing wrong with the Crumley cases, and this is why she may get a new trial, is the fact that, the teachers, the principals, completely scot-free. Yeah, totally political, ladies and gentlemen. And don't get me wrong, but as soon as we criminalize being bad parents, hey, they're coming for everyone. They're coming for everyone, ladies and gentlemen. Next, a little more information on the Karen Reed trial. The lead investigator in the Karen Reed case, who was removed from duty over text messages, allegedly sent another profane text a few hours after the mistrial was declared. At last summer's trial, Michael Proctor admitted under oath to sending text to colleagues referred to as Miss Reed as a whack job and a nutbag with, quote, no ass, end quote. Now, according to the new motion filed by Miss Reed's defense team on July 1st of 2024, the day Reed's first trial ended with a hung jury, Proctor sent Assistant District Attorney Adam Lally a text that read, yeah, didn't watch effin' Jackson's closing for good reason. Like all of us, the anticipation and the anxiety of the verdict has us all on edge. The Jackson was, Proctor was referring to, was the defense attorney, Alan Jackson. Now, the defense motion asserts that Proctor's message to Lally is an example of impeachment evidence that can be used to discredit a witness. Other text messages sent by Proctor that came to light at last year's trial include, "No nudes so far. Hopefully she kills herself," and comments about her leaky balloon knot. The last text was in reference to the inflammatory bowel disease that Reed suffers from. Now, Proctor, who read those messages aloud on cross-examination, conceded that they were unprofessional and inappropriate. Well, Proctor, who's been suspended from the Massachusetts State Police without pay since July, is awaiting a disciplinary action over allegations of misconduct. He's set to appear before the state board for the third time in March, specifically on March 13th. And that hearing will be a continuance of a hearing Proctor attended last Monday on February 10th. Now, Reed was also in court last Monday when she lost a bid for the court to drop the charges against her, which include the second-degree murder. Now, Reed is accused of hitting her boyfriend, now former police officer, Jonathan O'Keefe, with her SUV on the night of drinking and leaving him to die in a blizzard. O'Keefe was found dead by the curb outside the fellow Boston police officer's Canton, Massachusetts home, and Reed's defense attorneys maintain that she is being framed. But we won't have to wait much longer. Her trial begins on April 1st. Oh, and let's not forget, the Massachusetts Supreme Court said she can go back to trial on all of the charges because her attorneys, the prosecutor, and the judge all said or failed to ask, had the jury reached a verdict on any of the counts. And since they failed to ask, really what the court said was, you got an issue, I guess, of malpractice against your attorneys because they should have asked. The judge has immunity, the prosecutor does too. So will that be the basis of a post-conviction relief if Karen Reed is convicted? Probably. Next, a pastor pleads guilty. And like I said, no, it's not one of those kind of pastors. He just tried to kill his family. That's right. A former Kansas children's pastor who attacked his family and set their house on fire to hide his financial problems has pled guilty. Matthew Lee Richards was charged with 5 counts of attempted murder and 1 count of aggravated arson with bodily harm after the September 16th, 2023 incident that occurred at their home. Now, police said at the time the victims were his wife and their 5 children. And the prosecutor said that Richards entered guilty pleas to 2 counts of attempted first-degree murder in that case. Now, the probable cause statements state that police received a 911 call about a house on fire that day, and the child called 911 to say that their father was chasing them with a knife. Another call told police that she had actually been stabbed. When police arrived, they quickly found 3 victims with stab wounds waiting for help outside of the house. Smoke could be seen coming from inside the house, and emergency crews stated they heard an explosion coming from the garage at the same time that the garage doors bowed out because of the explosion. Anyway, police said an adult female believed to be Richard's wife and 2 children were rushed to an area hospital in critical wounds with life-threatening stab wounds. Another child told police that the family had been in bed when dad came around stabbing everybody, and that's when they all ran outside. 2 other juvenile-aged children and 1 adult child were taken to the hospital with minor injuries. And police ordered Richards to come outside, and he was taken into custody. After he was medically cleared, he told investigators, quote, "I stabbed my family," end quote. Now, Richards explained to police that he had not been honest with his wife regarding their financial situation, and the family was expected to be evicted that very day. They hadn't packed, and they were completely unaware of the situation. So let's kill my family and burn the house down. That makes complete sense, doesn't it? No. Anyway, Richards allegedly formulated this plan to burn down their house earlier in the evening. He set the fire first, then got a knife, and Richards said memories of the incident came in flashes from there, but he remembered thinking that he was a monster and that he thought it would be better if they all died rather than waiting for his kids and wife having to deal with the trauma of finding out the truth. As I noted at the time of the incident, Richards was a child pastor at the Crossroads Christian Church, and the pastor there says that all of the injured family members will survive, including Richards' wife, who was taken to the hospital in critical condition. Also said that he had no idea that the family was facing eviction, and had he known, he would have tried to have helped. The pastor also noted they were completely caught off guard and shocked by what had happened. Richardson was the child pastor for the last 7 years at the church, and he was responsible for ministry of pre-K through 5 graders. Richards is scheduled for sentencing on March 26th. Next on the docket, 72 years old and hooker and blow. What could possibly go wrong? So an Indiana man, while being interrogated, blamed 2 women for a plot in which he poisoned his wife's Coca-Cola, but the defendant still admitted that he carried out the act in spite of the other's alleged murder plot. That's right, the Wayne County Sheriff's investigators tried to pin Alfred Ruff down on precisely when the co-conspirators, let him know of their plan. And so the interrogation goes and you're saying they hinted around to it? There's no hinting around to this. One of them said, it's either they said it or they didn't say it. Well, needless to say, the wife survived the poisoning. Ruff relayed in a rather lurid story in which there was a series of incidents when he put a substance in his wife's Coke, and then when she went to sleep, he had relations with one of the 2 other women, or they, quote, put on a show for him, end quote. He said the murder plot was over his life insurance money. Anyway, Ruff maintained that he did not know what the substance was and that it was their goal, not his, to attempt the murder. He said, quote, I didn't want to kill her, end quote. As an investigator pointed out to Mr. Ruff, however, Ruff nonetheless carried out the action, but you were the one giving her the stuff in order to do it. That's right. Well, Ruff is the only person on the hook for the incident, according to the Wayne County prosecutors. Anyway, Ruff is currently also serving a 4-year prison sentence plus 5 more years suspended for aggravated battery. Now, the court acknowledged mitigating factors when he was sentenced on that case because he's now 72 years old. He has some health concerns, and he had a previous law-abiding life, as well as cooperating with investigators, showing genuine remorse for what happened. Anyway, that crime was a result of circumstances unlikely to reoccur, the court noted when coming to that sentence. Guess it didn't. Anyway, next on the docket, this day in legal history. On February 13th, 1973, Herbert Mullen was arrested in Santa Cruz, California after a killing spree that resulted in the death of 13 people. Now, Mullen's case brought attention to the issue related to mental illness in the criminal justice system and the legal standards for the insanity defense. Also on this day in 1991, the air campaign of Operation Desert Storm concluded, leading to the commencement of the ground assault phase. Remember, shock and awe? Anyway, the Gulf War raised questions about the application of international law, including the legality of preemptive strikes, the treatment of prisoners of war, and the enforcement of the United Nations resolutions influencing U.S. military and foreign policy. I remember that. I was getting ready to get on the bus, and then the next thing you know, the war was over in like 3 days. All right, don't need you anymore. Get off the bus. Turned out okay, I guess. And on this day in 2016, the death of Supreme Court Justice Antonin Scalia. He was found dead at a ranch in Texas. He was down there on a hunting trip and passed away, I believe, of a heart attack. Anyway, that death created a vacancy on the Supreme Court, leading to significant political debate over the appointment of his successor and impacting the ideological balance of the court. And a lot of people don't know this, but some of the best criminal defense decisions were written by Justice Scalia. I know you wouldn't, hard to believe it, but he said, no, you have to look at the Constitution. And I know lots of people that were like, I can't believe that this decision was written by Justice Scalia. I hate him on everything, but my God, he gets it. This is a great decision. Anyway, passed away today, 2016. Seems like it was yesterday. Actually got to see him speak once when I was at Naval Justice School in Rhode Island, and then also once here in Denver. He was a very interesting speaker indeed. And finally, our dumb criminal of the day. So when this dumb criminal of the day threatened to call police during an argument, a woman pulled out her dildo and began striking the man with it, according to the Florida Police Department. Now, the alleged sex toy attacked or was charged with domestic battery. Now, police say that they were dispatched Sunday to the Fort Pierce residence in reference to a disturbance in progress involving a 52-year-old man and Julissa Negron. She's 50. The victim told police that Negron was staying with him while she was gathering clothing before relocating from Puerto Rico to Connecticut to start her life over. Negron and the victim were married back in Connecticut in 2003. While Negron was well behaved a day earlier, the victim told police she was drinking alcoholic beverages, resulting in her acting disorderly, and started arguments about who he follows on Instagram. At one point, Negron allegedly began to get in the victim's face, which he believed was to antagonize him. And when the man warned that he would dial 911, Negron pulled out a dildo and began to hit the victim with it. Now, the dildo is not further described in the arrest report, which does not indicate whether police confiscated the alleged weapon of the battery as evidence. When police arrived at the man's home, he warned that Negron was inside naked and would flash officers. The man also explained a history of Negron's abusive behavior prior to her leaving for Puerto Rico, to the point where he needed to leave his own home. Negron was reportedly quite agitated, disorderly, and smelled of an alcoholic beverage when police sought to question her, and they were unable to get a clear story from Ms. Negron. Needless to say, Ms. Negron was arrested at the scene and booked into the county jail for misdemeanor battery. She was ultimately freed on a $1,000 bond. Negron is scheduled to be in court again on March 24th. The judges ordered her to have no contact with the victim and don't possess any deadly weapons that can be used for a battery. Don't have any weapons, Ms. Negron. All right, that's all we have for today, ladies and gentlemen. Thanks for watching. We'll see you next time. And remember, the Constitution matters.